Hello, everyone. Welcome to our channel. In this discussion of the legal aspect, we do have Advocate Akash R Rao with us. Welcome to this session, Akash. And I'm really excited to
Thank you.
speak
Thank
to
you.
you all about the bail matters. I think that's a new aspect to me because I am
Correct.
more into the corporate side. And
Correct.
yeah, let's get started. Can you please introduce yourself to all our audiences?
So I'm Akash Rao, advocate practicing based out of Bangalore. So I've been practicing independently from 3 years, and I've been about 7 years. I have about 7 years of experience. I was enrolled in the year 2016. Later, I joined my seniors firm called Muchandi and Company, where I had a chance to deal with all sort of laws. Probably maybe it will be criminal laws or be anti-corruption laws or civil laws or matters pertaining to transfer of property, also matters pertaining to due diligence, and probably going out for registration of concerned dates for the concerned jurisdiction registrars. So all these sort of matters at the appellate level, at the trial level, I was exposed to. So after a period of 4 years, I thought, okay, it's time's up. I had to do the real thing now. I'll have to start pulling up my socks and start on my own. That's when I started this firm called Akash Rao and Associates. The office is in Vasanthanagar, Bangalore, near to Mount Carmel College. So I practice mainly on the criminal laws as well as the writ laws. I practice before the High Court of Karnataka, also before the trial courts across the state. So this is about me.
Yeah, and also to note that you are the first generation advocate in your family. Like, how does that feel? Because that seems very personal to me as being the first advocate,
See,
first generation advocate. How does it feel to you?
so basically, I'm an accidental lawyer, to be very honest with you. Because I never intend to do law. So I was basically practicing company secretary.
Okay.
So many of people, probably my seniors in my college told, doing law along with company secretary would help you, probably fetch you a lot in terms of money when you
Mm.
go for a corporate work. But the irony is that, I started law, probably I started law and company secretary together, where I completed my law first, but I still, even as on today, I could not complete my company secretary course.
Okay.
So, and when I started working, probably started seeing the courts, I started
Mm.
seeing the matters at a different level, probably different types of matters,
Mm.
probably matrimonial or corruption matters or anything of such sort. I felt, okay, this is much interesting. Okay, let me see this. Probably when I started my practice, when for a litigation lawyer, it's always the first initial days are very tough. You don't get paid much, or in terms of money,
Mm.
or you don't understand how it works.
Mm.
You get
Mm.
kicked back. So all
Mm.
these sort of difficulties you face. Even then, that point of time, I was frustrated.
Mm.
I really felt, I need to get into a corporate work where my life is, it's settled kind of a thing, and I get, certain sort of sum of fixed money, and
Mm.
so there's the year 2020. I think probably COVID changed a lot of things.
Mm.
When during the period of COVID, I started. I just left my senior's office on a pretext that probably let's see something else.
Mm.
Let
Mm.
I was still confused even in the year 2020. I was still confused. Okay, should I get into corporate or should I
Mm.
get into some tier one law firm
Mm.
or start on my own?
Mm.
To be very honest, probably I had only two
Okay.
cases when I
Mm.
started independent.
Mm.
After which, even now, I don't know. It's just going through the flow. Probably I feel one should have passion towards what you're doing, especially towards this law or probably practicing for the courts. I feel one should have passion. So
Mm.
probably that passion, has taken me this far. That's what, and
Yeah.
it's taking me through.
Yeah, and also I would like to say that that's the first brave step that you have taken. That's a very brave move. I think nobody would like to come out of that comfort zone and do that. Okay. Yeah. So that's so nice to hear. And speaking about the
Correct.
bail. So what is this bail, and what does it mean that a person is on bail?
Bail is nothing but is a kind of a protection. For suppose A registers a complaint against B for so and so offences, let it be under IPC or any other laws. B is a person who is apprehending arrest. B is a
Mm-hmm.
person who is apprehending arrest. So bail is nothing but a protection. It's not that you are acquitted from the case. It's just a protection until the completion of the trial. So
Mm-hmm.
until the completion of the trial, you are out on bail, which means you are out of the jail. You're out of the jail and subject to certain conditions.
Okay.
And but of course there are a lot of restrictions.
Mm-hmm.
You are not supposed to. There may be conditions imposed in serious matters, which
Mm-hmm.
says you're not supposed to go out of the country or go out of the jurisdiction of this
Mm-hmm.
court or something else. You're not supposed to tamper the witnesses. There are certain conditions which which says okay, you're confined to, or you're
Mm-hmm.
probably, if I have to tell you, you're bound to.
Bound
So,
to.
which means bail. Bail is nothing but you're free from the court. You're not in the jail. That's the whole thing. If I have to tell in the layman's language.
Okay. So you are just out of the jail, but you are not released or from the allegations that are imposed in that particular case.
Correct.
Yeah.
Correct. You're still an accused. You're still an
Yes.
accused. You still have to undergo trial.
Mm.
And after the appreciation of evidences, after the argument from both the sides, then comes something called judgment. Then
Judgment.
the court will decide whether you're acquitted or you're convicted.
Yeah. And what are the kinds of bails that we have in our legal system?
Yeah, bail, is divided into probably two to three categories. One is a
Mm.
regular bail.
Mm.
Regular bail is in the sense, the accused is in the jail and
Mm-hmm.
he files a bail application through his pleader or his lawyer before the
Mm.
magistrate court or maybe the sessions court or the high court.
Mm.
And the court will consider consider the aspects, and if he's been released on bail, that's called a regular bail.
Mm.
There's something called anticipatory bail.
Mm.
Anticipatory bail is nothing but a bail before arrest.
Mm.
Suppose you have an
Okay.
apprehension of arrest.
Mm-hmm.
There's an FIR registered against you. The police
Mm.
are looking out for that accused. Or
Mm.
probably the police are looking, trying to file a complaint against the accused.
Mm.
That's when
Mm.
you approach the Court of Sessions or the High Court.
Mm. Mm.
And you file an application under Section 438 of CRPC.
Mm.
And you seek a protection.
Okay.
And the anticipatory bail, there's something called interim anticipatory bail.
Mm.
Probably for a bail application to be decided, it will take about a week or 10 days of time.
Okay.
And in the middle of which there's something called an interim anticipatory bail application which has been filed, which can
Mm.
be filed. And it's
Mm.
up to the jurisdiction discretion of the court to entertain it or not.
Mm.
So there's something called interim anticipatory bail means until the completion of the bail application, of the
Mm.
hearing of the bail application,
Mm.
this what do you call it? He has a protection.
Okay.
He will not be arrested. And there's
Okay.
something called transit bail.
Yeah. Mm.
There's something called transit bail, which says you can apply for a bail
Mm.
sitting in one place for an
Mm.
FIR registered in another place. Suppose an
Okay.
FIR is registered in Bangalore
Mm.
and
Mm.
you take an anticipatory bail from Mumbai.
Mm.
This is also something called some sort of anticipatory bail.
Mm. Mm.
And
Mm.
there's something called parole also. You're convicted for an offense, but
Mm.
you have to come out for a few number of days for a
Mm.
valid reason. The
Mm.
court will allow, you can approach the high court for a
Mm.
parole application, and you're out on parole. You think,
Mm.
you have some obligation to do some work, which is
Mm.
very
Mm.
important. Because
Mm.
there's some case laws which cases where they have seen the mother is ailing
Mm.
and she's in the hospital bed and the
Mm.
accused is in the jail. You
Mm.
never know how long he is there. Probably sentenced about for 13,
Mm.
14 years. So the
Mm.
offense is punishable in section 302, which deals
Mm.
about murder. In
Mm.
such cases, we have seen cases where we applied for parole
Mm.
and, he's out for a few days.
Okay.
We
Mm.
can't call it a bail, but it's something called parole.
Parole. Okay.
So
Yeah. And can we file for the anticipatory bail even before the FIR registered? Suppose today uh, X threatens B that I'm going to file a case against you, which is going to be non-bailable or some for some grave offense. Imagine for a rape case. So, or for a domestic violence case, 498A. So, in that case, can that person, even before a complaint, a formal complaint is given or an FIR is registered, can they file for anticipatory bail?
Yes, they can. Because the anticipatory means the word anticipation means anticipation.
Mm,
That's how the word anticipatory bail came from. Anticipation means you're anticipating arrest, you're apprehending arrest. Suppose you get a threat from A threatens B, saying
mm,
he will file a complaint against you for so and so offenses. And but before for filing an anticipatory bail, even when
mm,
an FIR is not registered, there
mm,
are a lot of cases. We already the landmark judgment in Guru Baksh Singh case, the Honorable Supreme Court. There's one case called of Savita Agarwal, which
mm,
the Honorable Apex Court dealt with, which
mm,
which says even though the FIR is not registered, if the
mm.
if the accused or a person who's apprehended to be arrested shows some material evidence to the court,
Okay.
probably call recordings or
Mm,
probably WhatsApp messages, saying
mm,
if there's someone who's threatening him, or
mm,
probably even a call from the police station, or probably
mm,
a notice under Section 41A of CRPC, that would
mm.
suffice, and you can apply for an anticipatory bail. But
Okay.
there must be some reasonable documents or
Mm,
evidences or materials you need to show it to the court. So,
mm.
to show that you are apprehending arrest.
Okay.
We usually anticipatory bail when there's not an FIR registered. We usually do it in cases such as 498A,
Mm,
so relates
mm,
to domestic violence,
mm, mm,
where the wife approaches the police station, and
mm.
and even now when the Supreme Court says in 498A cases you are not supposed to arrest a husband without conducting
Yes.
a preliminary inquiry,
Mm, mm, mm,
uh, which dealt in Priyanka Srivatsava's case.
mm,
So there may probably there's a notice which is being sent out to the police station,
mm,
or the police may refer it to Vanita Sahayavani, which is nothing but a
mm.
mediation center kind of thing.
Mediation center. Mm,
When you get a notice from there, you can apply for an anticipatory bail, and
mm,
the court will definitely grant you bail if you are apprehending arrest. So
mm.
basically, you have to show some material evidences, but you can definitely file a bail petition even though FIR is not registered.
Okay. And yeah, so these days the transit bail is something which is in very hot discussion. That is because of the globalization and the expansion. People are staying in different areas. So, what actually is this transit bail and how different it is from anticipatory bail or regular bail? So, we know, as you explained, it means that travel, like who can avail that one? And sometimes we have seen that in 498A, when they know that the person is outside or residing somewhere else, then they do file it. Like even they can file case against sister-in-law, and even the husband sometimes may be going out for work or they may be residing separately. So how does that work actually?
So transit bail is nothing but suppose an FIR is registered here in Karnataka. He
Mm,
applies for an anticipatory bail somewhere sitting in Mysore or
mm,
somewhere in Bombay or Maharashtra,
mm, mm,
where he applies for a transit bail. Transit bail is even considered. It's end of the day you will have to come before the trial court,
mm,
before the
mm,
concerned magistrate, and seek
mm,
a regular bail. Even
mm,
though you seek an anticipatory bail to the court of sessions, you
mm,
will have to get back to the trial court,
mm.
and you will have to seek for an for a regular bail once a charge sheet
Mm.
is filed. So
Okay.
anticipatory bail is a bail where you file for the court of sessions where the court has jurisdiction.
Mm, mm,
Suppose there is an FIR registered in Jayanagar. You approach
mm,
the court of sessions in Bangalore, City Civil and
mm,
Sessions Court.
mm,
That's called that, or probably even if you are arrested before the Jayanagar police station, you
mm,
file a regular bail application under Section 439 of CRPC
mm.
before the concerned court, which is the
Consent.
jurisdiction of the court. This is nothing.
Okay.
This is all about transit, anticipatory bail and regular bail. Transit
Mm,
bail is something where you sit in another state and
mm,
you apply for
mm,
a bail, which is probably happened in for a crime happened in Karnataka.
mm,
But
mm.
those sort of bails are always given for a very limited period of time.
Okay. Mm,
anticipatory bail and transfer bail are given for a limited period of time, not bail where you seek a bail. When you get a bail, it will be until the end of trial.
Okay. What do you mean by this bail bond or securities? Like, is there any problem for a person if he becomes security or provides any bond in the court to avail some person in bail?
See, bail bond is nothing but you give an undertaking. The, bails are subjected to sureties.
Okay.
That you will not flee away from the jurisdiction, or you will not tamper the witnesses. You'll not probably violate the bail conditions. Is what one word. If I have to tell you, you're not basically you're not supposed to violate the bail conditions. That's what the bail bond says. And sureties are nothing but probably if A has committed some sort of an offense, probably his friend or his mother or his father or his brother or any relative of his can produce some called surety, saying probably you have to give his bank documents. So bonds are nothing but you'll have to give sureties before the court. Probably in terms of saying you. So this is the sort of what do you call, your bails are always subjected to sureties. Probably you have to satisfy the courts, saying basically you're not flee away from. So any of your relative can give us a surety. Probably you have to give us photos, probably the property what he possesses. It's nothing like suppose B is the accused and C is the person who's giving the surety. If B commits something, he violates something of such sort, probably there'll be something applicable to C also. Probably even the C might be a little affected. So that's the reason, what we call is, surety, probably there's probably not as, applicable to B, but, even C will have some sort of an impact.
Yeah,
Because
some
basically there's
repercussions.
something called, correct, so some repercussions, he will, end of the day, he will give something called as a, what do you call, undertaking that, if at all he does something, I'll be responsible. I'll make sure he doesn't flee away from the court. He doesn't tamper the witnesses, or he doesn't violate the bail conditions. So these sort of things, probably, she would have given an undertaking, and to that undertaking, there will be some repercussions to see also as well.
Okay. Common myth that, or the common thing that I've heard from many people, and also I have seen many movie dialogues regarding this, is only gazetted officers or government officers or people of high value, like court has to prove that yes, this person can be the security. Only then they can use security in bail cases. How true is that one?
No, I don't say it's true. There's always, something called, if the court specifically orders that, the accused has to produce something called as a solvent surety. Probably government solvent surety. Then that's when, the person, as you told, probably the gazetted officer or any other person who's in a government job has to produce a surety. There's something always the word called solvent surety which is being used in not all the cases, but in certain cases where the court feels the accused might tamper the bail orders or something as such. That's what they call as solvent surety. Solvent is nothing but the government surety.
Okay. So a person who's of stable income or a stable lifestyle, who is not
Correct.
mentally ill,
Government.
yeah, like a
Correct.
normal person.
Correct. So
Yeah.
that's what that's what how what even the normal person can possessing a property, possessing a job, and possessing a permanent address can give a surety. That's called a regular surety. There's something called solvent surety when these things apply. Like the person who should be in a government job, or probably a gazetted officer or someone else.
And how about the permanent address? Like whether it has to be in that territory of court, or I mean jurisdiction of court, or it can be somewhere else. imagine it's a Bangalore court and there is some person from Mysore belonging to Mysore. So can he give surety in Bangalore court? Will that stand?
He can, but basically he'll have to show some sort of properties or something which is in the jurisdiction of the court.
Jurisdiction. Yeah.
So that's when probably comes in. So probably from if it's a mother or a father who's giving surety,
Mm-hmm.
then
Mm-hmm.
that would not impact much. If someone
Mm-hmm.
who's coming, portraying himself as a friend to the accused, that
Mm-hmm.
the court says that it's all. To be very honest, sureties are nothing but discretion of the court.
Yeah, true. That's true.
It's all
And
discretion
also
of the court.
depends on the facts of the case and the gravity of the offense that he has committed.
Correct, correct.
Yeah. And what happens when a person doesn't get bail? Like how long will he has to be in jail? And who will bear that expenditure of that person who's in jail? Is that a state expenditure or any of the parties has to bear it? How about that
No, it's a
part?
state expenditure. The person who is in jail,
Mm,
jail belongs, it's a body.
mm,
It's a government body, but the government, takes care of the expenses of the prisoners.
mm,
They have their full funds which have been allotted,
mm.
and which has been done. But the first question, what you asked, how long a person should be in jail,
Yes,
it
yes.
all depends on the nature and gravity of the offences,
Mm,
as
mm,
we discussed earlier.
mm,
Suppose a person who's committed a crime, something related to money. It
mm,
depends, what is the money involved, and
mm, mm,
how many number of people are being cheated here.
mm, mm,
We have a matter pertaining to murder.
mm,
Who's in jail, the accused is in jail from
mm,
probably from 3 or more years.
mm, mm,
He's filed several bail applications, and all
mm,
his bail applications are rejected
mm,
because of the only fact that he is being the accused number one
mm, mm.
in the crime.
Okay.
He's accused number one in the crime, and
Mm,
he's has a lot of allegations against him. The gravity of offense is more, and he's a prime suspect. The court will
okay.
always decide, what is the risk involved,
Mm,
in
mm,
enlarging a person on bail.
mm,
So, if so, supposedly the investigation is completed and the charge sheet is filed,
mm,
the
mm,
court will always think of granting the
mm,
bail. But
mm,
in these sort of grievous offences or gruesome offences,
mm,
the
mm,
court will always be very cautious in granting bail orders.
mm, mm,
So the Supreme Court has always said, be very cautious in granting bail orders,
mm,
especially in the matters pertaining to probably high stake matters pertaining to
matters.
matters related to cheating or any
Mm,
other,
mm,
needy matters or
mm,
the misappropriation matters or
mm,
something else,
mm,
and also
mm,
matters pertaining to offense relating to the body. Probably,
mm,
probably it's a murder matter.
mm,
If it all, and probably he's an habitual, offender,
mm, mm,
and he's been previously, there are a lot of probably there may be a lot of crimes, registered against him, or probably there are a
mm,
lot of trials which are, taking place against him
mm,
before several courts maybe.
mm,
In
mm.
those cases, the court will be very cautious and probably not prefer not to grant him
Give him
bail,
the bail. Mm,
uh, in such sort of offenses, because the court would, the materials available on record,
mm,
would, probably the court would feel, if he's enlarged on bail, he may tamper the witness.
mm.
He may flee away from the country. And,
True.
it will cost a lot to the government or probably the police involved in the case to
Mm,
bring him back to the custody and
mm,
produce him before the court. That's
mm,
when the
mm,
court will always be cautious, and probably if at all he is not enlarged on bail, probably we have seen cases, the accused is in jail, even until the completion of the trial, even
trial.
after
True.
all sort of stages are complete in the trial and the court matter is set down for
Mm,
judgment. Even then, we've seen accused being in jail.
mm.
It all, to be very in the simple words, if I can have to tell you, it all depends on case to case basis.
Case to case. And also the grounds that is framed for availing bail. What are the common grounds that you make while drafting in bail applications? Like I'm an advocate and
Common,
I want to practice now and I want to draft a bail application? Like, what is the common ground that you would suggest me?
Common ground is always, you'll have to check. Basically, you have to find out the loopholes in the matter.
Mm,
The common ground should be, you can always say that for the police has not conducted a preliminary investigation
mm,
before registering an FIR.
mm,
That's one of the primary and a good ground what you can which you can avail in in cases which require preliminary investigation. Probably it's a matrimonial dispute,
mm,
and there are a lot of allegations which have been leveled against the
mm,
husband by the wife.
mm,
Probably the allegations may be true or might not be true. There are a lot
mm,
of cases, husbands are being, victims, in these phone integrity cases. There are genuine cases as well. But
mm,
there are also, a lot of false cases which have been, initiated by the wives.
mm.
In these cases, the police, many a times they don't conduct a preliminary investigation.
Investigation.
They straight away proceed further and register an FIR.
Mm,
So when you file an anticipatory bail or a regular bail for this sort of an accused or for this sort of an offense,
mm,
you can always say the court has not, the police has not considered, conducting a preliminary investigation.
mm, mm,
That's when there. The second ground is a moral ground. What you can always seek.
mm, mm,
There's something called a moral ground, saying you have certain number of dependents. The
mm,
accused has a certain number of dependents to take care
mm,
of. He has a
mm,
wife, he has children, he has his old age parents, and if at
mm,
all he is arrested,
mm.
the bread and butter of the family is gone,
Go.
and he is unable to earn. He cannot
Mm,
maintain the house.
mm, mm,
This is sort of ground what you take.
mm,
Probably the anticipatory bail you tell if at all he is arrested. But in the
mm.
regular bail, you say, if he is arrested,
Nothing
he
can be
cannot
done.
earn for the family.
Mm,
That's
mm,
one part. The third ground is the jurisdictional ground. You
mm,
can
mm,
always say he's the permanent president of the jurisdiction of the house, which is
mm.
within the jurisdiction of the court,
Okay.
and
Mm,
it's his own house, and he
mm,
cannot flee away from there. And
mm,
he has his parents staying in the house, and
mm,
after he has to come back,
mm,
he'll not flee away.
mm,
And of course, the third thing is you surrender to the court, saying,
mm,
whatever the conditions the court may
mm,
impose while granting the bail, it may be
mm,
imposed. I'm ready to abide by
mm,
it.
mm.
So these are certain common grounds what you take. Apart from this,
And
there are grounds you also take from case to case basis. Yes,
mm.
sir.
And that default bail, which says that the charge sheet has to be filed in so many days. I'm not sure of this, but I have heard of this law.
Correct.
Like,
Correct.
uh,
So there's something called a 90-day time period between the
yes, yes.
FIR and the charge sheet.
Mm, mm,
So the charge sheet needs to be filed within a period of 90 days.
mm, mm,
If it's not filed within a period of 90 days, the police have to file necessary application before the magistrate court,
mm,
and tell the reasons why the if a charge sheet is not filed within so and so
mm,
days.
mm, mm.
If the charge sheet is filed not filed within 90 days, you have an option of defaulting.
Okay. Yeah, that's what I was like. I had heard it from some people, but I was not
Correct,
sure of
correct,
that whether
correct,
it's such a provision or not. Okay, so you should be
correct,
knowing
correct.
about the facts and also about the laws to frame the grounds of the bail.
Correct, correct. So for actual aspects is all first you always say any bail
Mm,
petition you'll have to tell the court or probably you'll draft it saying by saying these are the sort of allegations which have been made in the complaint.
mm, mm, mm,
Based on the allegations made in the complaint, FIR is registered under section so and so.
mm,
So certain grounds, what you can tell is probably the for suppose grievous hurt under section
mm,
325 or
mm,
323,
mm, mm,
you can always say there are no allegations against as such in the complaint. But
mm,
even then, the police have invoked the offences pertaining to grievous hurt.
mm. True.
So these
Yeah.
are sort of grounds or what thing you frame first. Firstly, you'll have to go with the facts of the case. You'll have
Mm,
to tell what is the allegations made against you in the
mm,
complaint.
mm, mm,
Then you'll have to come to the grounds part. You'll have to
mm,
add something called grounds, and
mm,
in the grounds part, you'll have to step by step tell what are your grounds. How do you counter the
mm,
allegations made in the
mm,
complaint?
mm,
Then you tell because of so and so reasons the complaint intends to be false. and I'm entitled for a bail.
Mm.
At the
Yeah.
end of the day, allegations have to be, is a matter of trial. But
Mm.
the prima facie, you will have to show the court that, the allegations made in the complaint are not true.
Not true. And also, you said that the bail will be granted on some conditions, like you will not go out and you will not do that, you will not do this. Monitors all those things. Like, suppose if he goes out, how will the people get to know? Like, out of the country, you can take the passport, like, out of the state, out of the city, you cannot stop. How it is monitored, and how will the court get to know that, yes, this person has gone outside?
To be very honest, this is how it works. You always,
Mm.
the accused who is on bail, and,
Mm.
if there is a condition saying, he's not supposed to go out of the jurisdiction of the court without the court's permission, it's
Mm.
always, the accused must always file an application before the magistrate.
Mm.
And he'll have to seek permission of the court,
Mm.
before going out.
Mm.
And the court will also grant you permission,
Mm.
to certain conditions.
Mm.
Or the court will again, probably ask you to give some sureties,
Mm.
depending on where you're going.
Mm.
We had a client, who had to, travel to Paris, to United States on a work basis. His
Okay.
work
Mm.
demanded travel.
Mm.
So in those cases, the court had ordered, certain sureties to be given,
Mm.
and what do you call, that you will come back to Bangalore, you will come back to
Okay.
the city.
Mm.
So there are certain, to be very honest, you'll have to file an application,
Mm.
before stepping out of the country or the jurisdiction of the court. It seeks court's
Mm.
permission and then
Mm.
go out. The court will
Mm.
definitely give you permission if your reason is genuine.
Mm. Mm.
But we've also seen cases, where the accused doesn't inform the court.
Mm. Mm.
He goes out of the country or he comes back.
Mm.
It's always, the state has to monitor it, because even in the
Okay.
bail conditions,
Mm.
there'll be something, where the court would have ordered, you have to visit the police station once in 15 days, once in 10
Mm.
days.
Mm.
It's
Mm.
always the police who will have to, police or the complainant. The
Mm.
person who's filed the complaint has to monitor these things.
Mm. Mm.
And in these busy times, when the accused is residing somewhere else and the complainant is residing somewhere else, it's
Mm.
very difficult to monitor them also. A lot of
Yes.
times, the accused has in fact gone out of the country, never returned.
Mm.
Everything such as what has happened, definitely happened,
Mm.
perhaps.
Yeah. And will the court grant any kind of restraint order? Now, suppose if there is a complainant and the accused is given a bail, and complainant is like, if he goes out, he will call me, he will email me, he will send indirect messages. So, can court order anything, especially in 498A cases? Okay, the wives may feel that the husband may do that one, or it may be an attempt to murder case also, any other case wherein such things has happened. So can they give any kind of restraint order that you will not contact that person directly or indirectly? Like, hampering evidences is the other part. I do
Correct,
understand that,
correct.
but this is especially to the humans.
The tampering evidence is always there. It also implies that you're not supposed to tamper the evidence.
Mm.
Tamper the evidence in the sense you're not supposed to trouble her. That
Mm.
which deems that you should not get in touch with her. Unless and until apart from the court.
Mm. Mm.
The court can always refer you to mediation, and where the husband and wife can talk to each other. There's
Mm.
something called mediation center. Tampering of evidence also implies to the fact that you're not supposed to go trouble the complainant.
Okay. Mm.
And if you do anything of such sort, it's always the complainant has the right to seek for cancellation of your bail.
Okay. Okay. So that can be done based on the facts of the case.
Yes,
So that's all. Okay.
yes.
So, yeah, what do you mean by this arrest warrant? Is that mandatory in all cases? And what is NBW? What will the court give any kind of notification before arresting a person?
See, correct. The court will always issue summons. There's something called court summons or court notices what the court issues. In criminal cases, you receive the summons, you about, or probably if I have to tell you in another way, you have the knowledge of the summons, but still you don't appear before the court. the court will definitely exercise something called a bailable warrant.
Mm.
You know, you're always, you're not arrested. It's a warrant. The court, asks you to come. Probably the court constable or someone produces you before the magistrate court, and you'll be allowed on bail. There's something called non-bailable warrant, where you
Mm.
skip the court for probably more than 3-4 appearances.
Mm.
You don't appear before the court.
Mm.
There's something called NBW, which is issued, which is called
Yes.
non-bailable warrant.
Mm.
A non-bailable warrant is issued to the accused, and even then,
Mm.
the non-bailable warrant is subject to recall.
Mm.
No, the accused can always file a necessary application for recalling of the warrant
Mm.
under 70 sub clause 2 of CRPC,
Mm.
and again he'll be subjected to some fine amount or something
Okay.
as such, and the non-bailable warrant will be recalled. There's
Mm.
something after which the court can exercise something called cancellation of bail
Okay.
and bail bonds.
Mm.
So
Mm.
the bail will be can forfeited. Correct. So the thing is, the court will always give you a chance. Probably the
Mm.
court will issue summons. The court will issue notices. You don't respond. There's something called bailable warrant which has been issued. You don't respond. Then comes the NBW, which is called
Mm.
non-bailable warrant.
Mm.
Non-bailable warrant is issued when you don't appear before the court probably for consecutive hearings.
Mm.
The accused advocate doesn't appear before the court and file necessary
Okay.
application for your exemption of your appearance.
Mm.
That's when NBW is being issued. And
Mm.
even after the NBW being issued, it doesn't appear before the court. There's something called forfeiting of bail and bail
Okay.
bonds.
Mm.
Your bail will be cancelled, and even the sureties, whatever you've given, will be cancelled. And the
Okay.
accused will have to again apply for the fresh bail
Mm.
and seek a bail. And the court will
Okay.
then double think, whether to grant you bail or not.
Not. Mm. Yeah.
That's
Okay. So while preparing the questions for this, I saw a question in Quora. That's a platform wherein they ask questions. So they have asked one question wherein a, a female, she had posted a question that her son. Okay, so the police had come to their home to arrest her son, and she helped her son to escape from that home, and she was successful in that. So they hid him, and then finally they gave him the car key. She had explained the incident, and then he ran away, and the police couldn't arrest him. So the police threatened her that not only her son, but also they will file a case against the mother, that is a female, for stopping or for causing trouble in the duty of a police officer. So she had asked the legal advice for same, like if she was your client, what advice would have you have given her? Is that an
basically
offense
she should
to?
not.
Yeah.
Yes, yes. It's always an offense. You're not supposed to help an accused. First thing,
Mm.
it's a common law. Second thing, there are also provisions which says you are not supposed to, obstruct a police officer on duty.
Duty. Yeah.
That's a non-bailable
Mm,
offense.
mm, mm.
I would firstly advise her not to, obstruct the police
Police
officer on
officer.
person.
Yeah.
Police officer, who's discharging his official duty should not be
Mm,
obstructed.
mm.
Secondly, I would advise her, if she's been, arrested or something, then I would have advised her accordingly. Probably I would have sought her out on bail.
Bail.
Uh,
Yeah.
so that's how the regular procedures.
Yeah. Okay. So you should not be helping any person who is being arrested by the police officer, even though it's your family member, because along with that person, even you would be landing in trouble.
Correct. Very true.
Yeah. And yes, the last question that I have is, what are the biggest myths that you have heard about the bail laws?
See, bail laws, I've seen clients coming, sitting in my chambers,
Mm,
telling, the clients always believe, the layman, always think,
mm,
okay, you hire a lawyer and he goes to the police station, gets a bail and comes back. You would have seen
yes.
such
Mm,
things happening in
mm,
movies.
mm, mm, mm,
Probably the accused is arrested in the morning by,
mm,
probably in an hour or two.
mm.
He comes out bail. The lawyer
Yeah.
comes to with an application or probably
Mm,
a piece of paper to the police
mm,
station,
mm,
and he gets him out on bail, which is totally not true compared to
mm,
real life. real life, the bail for a bail petition to be decided, it takes about a week's time on an average
Mm.
to be decided.
Mm.
Even if it's a regular bail or an anticipatory bail.
Mm.
So this is one of the biggest myth.
Mm.
What I would like to tell the people in common who are not lawyers or who doesn't have much of a legal knowledge and who probably not much about the bail part. I would tell them, bail is not as simple as they think. They
Mm.
think, they just hire a lawyer, he goes to the police station, he gives something called some sort of a piece of paper and be is
Paper. Mm. Mm.
released on bail. That's not how it works. You'll always have to approach the courts by filing necessary application, by filing necessary documents. Then the court will decide whether to grant you bail or not,
Not.
depending on the offences.
Mm.
So this is one of the biggest myths I've seen with respect to
Yeah.
bails.
True, true. Even I have seen people like being deviated because of these movie scenes and all, where it judges
Correct.
go and advocates go and throw paper at judges. They're like, "See, I've brought this,"
Correct.
and all other things. And one more thing
So
I would
in
like to
real life,
add
you
here.
throw papers on the judge,
Mm.
there'll be contempt against.
Yeah, true. And also regarding the finding of facts or investigation part, many people think that it is the duty of the lawyer to investigate. Like you have to go and dig deep and find it. There is the series and all, right? There is one web series. I couldn't recall the name, wherein that advocate he goes and does the investigation. He goes to the crime scene. He does that. He does this. In majority of the cases, lawyers do not even go to the crime scene and see what has happened.
Correct.
Actually, they just rely on the uh, client's opinion, whatever they tell and whatever the information they give. You will make grounds out of that one.
Correct. So it's always, end of the day, you will have to probably read the papers. This is what
Mm.
it's always a black and white thing,
So,
which is, which the court believes in to be true. There's
mm,
some, if you have to tell me if the advocate goes to the crime scene, it is
mm,
told, it's always the merger or the which is drawn. There's something called merger, what they do,
Maja. Mm,
which is done by a police officer in charge of the
mm,
case.
mm, mm, mm,
What he does, he goes to the crime scene, he does a merger, he takes some experts along, he takes some witnesses along, he does a merger, and something called a merger report is done. And
yes.
based on that report, the court will come to a conclusion or what is the exact thing which has happened,
Mm, mm,
and based on which the lawyer argues before the court.
mm, mm.
And the investigation part is always done by the police officer in
Police
charge
officers.
of the case. So
Yeah.
based on the papers, it's always open to the accused. If at all
Mm,
he's aggrieved by any sort of report or filed by the police,
mm,
he can
mm,
always challenge it.
mm. That
So
that is an
the
open
law
option to the client.
correct, correct. For my knowledge, for my understanding, for my practice, I always feel the work of a lawyer is uh, between himself and the court.
Mm,
It
mm.
is always, the lawyer always has to see what has to be disclosed to the court by not misleading the court.
Good.
So this is the duty of a lawyer, let
Yes.
he, based on the papers, what's being filed, what the investigation materials which are available on record,
Mm,
he argues before the court, he builds up the case, he does his own research, he finds any loopholes in the matter.
mm.
That's what the work of a lawyer is actually is, rather than what we see in movies and web series. I think.
Yeah, very true, very true. I totally go with you on this one. Yeah, so that's all about the with all the questions that I had regarding whales. So thank you so much for spending your time. I honestly learned a lot, and I'm sure people whoever are watching this and have come till here definitely would have liked and found this session very insightful. And also, I have pinned Advocate Akash's number and also his address in the screen. So you and also it will be in the description, so you can check out for the details. And if you have any questions related to the bail, you can post in the comment section, and also you can connect with the Advocate Akash and get your bail sorted. As said by him, he takes cases all over the state of Karnataka and in all the matters that he listed, like matrimonial case, criminal, civil, and any cases you can connect with him. And please do not ask for pre bono or pre charges. We have, even advocates have bill to pay, so definitely please pay us.
Thank you.
Please do
Thank you.
not ask for
Much
pro
needed.
bono thing. Yeah, I always tell this to everyone because everybody asks, we want free legal advice. Yeah, we have studied a lot. We have burnt night
No,
candles.
we do,
We have
we do give free legal advices. We do pro bono matters for people, who really need
one
of it,
need. True,
who are
true.
really in need of such, such services.
Mm.
We have, clients, probably, who are, probably filthy rich or something as such.
But still,
Who,
they don't want to pay.
probably not from them. Yeah, they don't want to pay.
Yeah, that's true. This is for all those people who can afford it but still don't want to afford it. Please do pay. Please do not ask for pro bono and all of these things. Yeah, so that's all I had. Again, once again, thank you so much, Akash, for spending. I think we spent around 1.5,
Thank
2 hours speaking all about bails. Personally, I have, as I said again, I have learned a lot. I learned so many things, so many technicalities, so many things. Um that I'm not totally exposed to, as not at all aware of, like for example grounds of bail and kinds of bail, transit bail, and also about the bond securities, the difference between them, and so many other things. I had a great learning. Thank you so much. More than
thank you.
sections, you brought in your experience, your expertise. That was very much appreciated, and I think all the people who are watching it would definitely appreciate that expertise you're bringing into the table. Thank you once again, and hope we
Thank
cross our
you.
paths again in the small world.
Yeah, definitely.
Yeah,
Thank you.
thank
Thank you very
you.
much.